Good day, this is the online lecture for LML4805 Learning Unit 8, Insurance Warranties. I will reference you to Addendum A. This PowerPoint will focus on warranties, but please look at the Addendum A, which gives you a bird's eye view. Please study and read the cases as well as the articles, and read your study guide and study the parts in Renniken et al. Referenced. It's very important that what we are talking about has an impact on what is necessary for a valid insurance contracts throughout all of these learning units. The specific one refers to more additional terms, accidentalia, that people will add on to contracts, but it's still quite important because, of course, it is an essential part, again, for the validity of insurance contract. So warranty is something that insurers utilize to add on to whatever rights they already have under common law. So you will have very specific rights and duties of both the insurer and the insured as they exist under common law. A warranty adds to those rights of an insurer. It gives them an added thing to utilize to enforce duties of an insured. It's something that we brought into our law from English insurance practice and English law. And therefore there are certain terminological and conceptual issues that arise, and you'll see that much later on as I discuss the statutory modifications. And please, at this point, I'm already going to say, read the cases linked to the statutory modifications, read the statutory modification and understand them particularly, but also the criticisms against it. So it is a non-essential term. A warranty is a non-essential term which would entitle the innocent party to claim for damages but will not relieve them from fulfilling their obligation, and we'll get to that shortly. Get two types of warranties. A warranty that a certain fact exists, so that is an affirmative warranty. And then you get a warranty about the future state of affairs. And that is something that you say you will comply with. For example, and I know I use a car and the house and people as examples often, but they're the simplest examples. For example, if I say that, that the car will be in a locked garage, that is a promissory warranty. There are other types of warranty. You get of facts, of knowledge, and of opinion. So what happens when there's a breach of warranty? And here, please keep separate in your head promissory warranties from affirmative warranties. A breach of an insurance warranty is nothing more than a breach of contract, because of course this becomes a term in a contract, so it is just like any other breach of contract. The insurer may resolve from the contract and or claim damages, and of course that is dependent on what that specific clause states. The insurer may resolve from the contract from the date of the breach, and this is quite important. So it does not go back and change the past. It's from the time of the breach. Of course, if the breach is an affirmative warranty from the start of the contract, well, that is from when the contract may be resolved from. The insurer incurs no liabilities for claims that arise after the breach, but of course, anything that has happened before the breach. So let's say I say that I will be putting my car in a locked garage. I am driving on the road, I have an accident, I'm mainly the person who caused the accident. But the other party is also liable for some of it. So in that instance, the insurer will have to pay for that. I then bring the car back, it's slightly damaged, so instead of parking in the garage, I'm too distraught or whatever it is, I leave it on the road and it gets stolen. The insurer will be liable for what happened during the accident because that happened before the breach, which was, of course, not locking it up in the garage. But it won't be liable for the theft of the vehicle. So before we start looking at statutory modification, I do want to just emphasize one point, that when it comes to promissory warranties, it is the time of breach that separates out the duty of the insurer to act. Yeah, let's just remember that. And before I also start talking about this, we're talking about the same statutory modification that occurred to resolve the issue around the situation created with misrepresentation. So the statutory modification that we will be looking at are the ones that were enacted really to try and resolve parts of those issues. And there's really the reason we have them applied to both is, of course, warranties come from English law and misrepresentation is a concept of Roman Dutch law. So that sort of amalgamation of things really does create a bit of a conundrum. So there will again be a reference to Kilingile here. There will be a reference to some of the similar things. So don't get too confused. Do try and keep warranties separate from misrepresentations. You can see how a positive misrepresentation could be also at the same time a warranty. If you say that you will, make a positive representation that you'll put your car in the garage, it is a warranty that's put in the contract. Therefore, you have then the choice between the delict and the contract. Yeah. Okay. So warranties, as utilized in English law and in our law, are usually interpreted quite strictly and against the insurer. That is because, of course, they are the ones who come up with the terminology and the clause in the contract. Even when it was done in that way, it was still operate in many instances quite harshly. So you could have a tiny breach, and that would mean that the insurer could avoid liability. The insurer also had the right to resile, no matter how trivial. So yes, they may not have had to could take away all of their liabilities, but they could just end the contract there and then not continue with it. The affirmative warranty does create this obligation, and it really did not matter if it had any bearing on the rest of the contract. It would just enable the insurer to resile from the contract. With promissory warranties, there was a little bit of a respite because, of course, the promissory warranty had to be causally connected to the loss. The results of decisions that seemed unfair made the legislator sort of find it important to intervene. So subsection 3 was added to section 63, and they said, well, any of these had to materially affect the assessment of the risk. So if it did not materially affect the assessment, you cannot just step back from the contract. And it was taken over without any alteration into the Long-Term Insurance Act and the Short-Term Insurance Act. And before we get to looking at specifically what happened in the Pillay case, it is very important that we keep in mind that the example that I'm going to give you now, which is that, so I make a promissory warranty that I will be locking my car in the garage, and I don't do so, and the car is outside on the public road, perfectly safe for some reason. but then a freak storm comes and destroys like number of houses and in cars, anything in its path. The fact that the car was not in the garage, which was destroyed in any case, means that there's no causal connection. Yes, so then 63.3 would have brought some respite. So let us continue. The court found that amendment should be considered. In that case, they said, hang on, this is still not enough. This is still not sufficient. And perhaps there's a way of taking amounts away from a claim as a way of saying, well, you did not fulfill the warranty as set out exactly. Maybe we should, an alternative was to perhaps have a proportionality principle. Further, the court found that the sections, of course, did not apply to promissory warranties, and that because there is that link with material to risk. And in the Pillay case, they said, well, then the test would have to be the same for negative and positive representations that then become warranties. So again, you can see already there's a little bit of the criticism is coming through, but also because, of course, the wording was not as it should have been. So again, I'm going to, having looked at all of the decisions in those cases, and I know those cases are meant for your study, you can see how misrepresentation and the tests that came up there are similarly applicable or found to be applicable for warranties. The test should be applied, when do you apply it and how do you apply it? And when do you have a ground for repudiation of the contract? The result was, again, that in 2003, the legislature further amended the Long-Term and Short-Term Insurance Acts, and requiring that there should be a materiality for the reliance on an incorrect misrepresentation. Even this further modification did not clarify or take that next step of truly providing some sort of help to the insured, really, in the situation. So firstly, just to summarize, I've put 2 points here that it introduced materiality unnecessarily because it already existed under common law for promissory warranties, and that the further amendments were aimed at nullifying the Killing-Gila case, ended up applying the reasonable person test to both. And this is perhaps something that the legislator should have been very mindful. So, as the statutory modifications today stand, there are 4 criticisms. Firstly, that the form was retained as is throughout throughout the amendments. Second, the terminology displays a lack of understanding of sort of how insurance law in this area has a bit of Roman Dutch law and English law, so it tends to sort of push them together in a very problematic way. It may have eliminated the disparity created in the materiality test for positive and negative misrepresentation, but it ignored all of the criticisms of both of those tests. So it did not take the opportunity to actually take on those criticisms. And of course, it passed up the opportunity to address other issues around the issues of materiality that had arisen. Now, before we get to the last bit on warranties, which is the specific issue of incorrect age, I think it is very important to state very clearly that my discussion of the statutory modification is a summarized version. Please start with the study guide, read that, understand it, then go on to your textbook, read that, read the cases, read all of those together, because it is a very complicated issue, and I would like you to understand that properly. I cannot go through every single case during these very short presentations, and I'm just providing you a certain amount of guidance. With the specific issue of incorrect age, where somebody lies, let's say, about how old they are, the legislator specifically restricted the common law right to rely on incorrect representation, to say there should only be an adjustment, either upward or downward of the sum, and that's it. You cannot take away the benefit altogether. And I think that perhaps was well done, in very specific, very direct way of dealing with things. And at this point, I am at the end of warranties. Thank you.